registered, and in this case, the re-registration is required only once. I would like to draw your attention to the fact that there are some cases in which the Ministry of Health may decide upon additional re-registration, provided there are some reasonable grounds for that related to pharmacovigilance. Now, on this slide, you can see the types of products, medicinal products, which may undergo the simplified registration procedure. So in the first case, you see the medicinal products for treatment of oncological diseases and some other diseases specified in the first box. The only condition for the simplified registration in this case is that such products had to be registered in USA, Japan, Australia, and some other countries specified. In the second box, you can also see some other products, original medicinal products, which were registered by EMA, European Medicines Agency. These medicinal products also may undergo the simplified registration procedure in Ukraine. And finally, I would like to stop on the medicinal products which are procured by the Ministry of Health with the assistance of the specialized international organizations. They also may undergo the simplified procedure of registration, and we will talk about that. We'll talk more about that later within this section on public procurement. For avoidance of doubt, I would like to mention that the procedure of registration is not identical for all of these products. Import licensing. Just one word here. I would like to remind you that in February last year, licensing on import of active pharmaceutical ingredients was cancelled. Now, current license conditions, relevant license conditions are approved by the order of the Ministry of Health, number 143. In the box in the middle of the slide, you can see those new requirements which entered into force starting from this month. And of course, you are aware of the those concerns which were raised by the importers, saying that you know, basically practically it is impossible to implement those requirements in this point. In the light of that, and also taking into consideration the fact that the law of Ukraine licensing business activities in Ukraine envisages that the relevant license conditions shall be approved by the respective resolution of the Cabinet of Ministers of Ukraine. We have a new draft of the license conditions, and this new resolution envisages that all these requirements specified in the box in the middle of the slide will become effective starting from 2018. But again, I just want to emphasize that at this point, this is only the draft resolution. Regulation of medicinal products. I'm sure you all are aware that we have 3 technical regulations in this point, which envisage that medicinal products will now have to undergo the conformity, what's the right word in English? The conformity assessment procedure. However, until July 1st, 2016, if the products which, if the registration certificates for the products are valid, they will not have to undergo such procedure. If the medicinal product, if the registration certificate for the medicinal product expires earlier, prior to the specified date, then of course this medicinal product will have to go to undergo the this procedure. At the same time, I would like to draw attention to another draft resolution of the Cabinet of Ministers of Ukraine, which envisages different terms for this procedure, and basically it says that the registrations, the registration certificates for medicinal products which are valid till the July 1st, 2017, they may be used, and the medicinal products will not have to undergo the this procedure. Price regulations. Here, I will speak on two aspects within this section. We'll talk about the declaration of wholesale prices and determination of the maximum markups. The procedure of declaration of wholesale prices was changing on an annual basis, starting from 2011, I guess. And due to this situation, at the beginning of 2015, we had a very miserable situation on the pharmaceutical market with respect to the public procurements. Basically, they were blocked, and in my opinion, there are several reasons for that. The first reason is that the comparative or reference procedure which was used is very complicated and complex and time-consuming. Second, the government authorities didn't have any, a single approach towards document processing, and sometimes the company were receiving refusals, or I would say groundless refusals. Finally, we also have to take into consideration the general situation on the market. If you remember, at the beginning of 2015, we had very frequent and significant changes in the currency exchange, and of course it was very difficult for the companies, for the business to plan and supply the products. So understanding the situation, the working group was organized to analyze this situation and find solutions. The work of this working group resulted in a new resolution of the Cabinet of Ministers of Ukraine, number 449, which was adopted in April last month and entered into effect in the middle of summer. This new resolution basically envisages the cancellation of the previous comparative or reference procedure, and it also has other changes with respect to the declaration of wholesale prices. As you can see, the timelines were shortened significantly, and the frequency of declaration of wholesale prices, or the limit for the frequency of declaration of wholesale prices was cancelled. The Ministry of Health was empowered to correct the declared wholesale prices of products, provided the average monthly rate of hryvnia to US dollar changed for more than 5%. State price inspection was withdrawn from this procedure, and the list of documents which are supposed to be submitted for the declaration of wholesale prices was simplified. Regarding the determination of markups, I would say that the resolution of the Cabinet of Ministers of Ukraine number 449 didn't really introduce any changes to the wholesale business. What I basically mean is that the maximum markup to the wholesale prices remains the same, 10%. The retail markups do not depend anymore on the purchasing price, and the maximum retail markup is established on the level of 25% on the purchasing price. Last year, the order of Minister of Health of Ukraine number 1000 was cancelled, and at this point we have two lists which are effective. This is the state list of essential medicinal products and the list of medicinal products for procurement. In the first case, you can see that we deleted end medical devices because the respective changes were introduced, as the state list of essential medicinal products does not extend to the medical devices. I should also mention that at this point the work is going on combining these two lists into one, which will be called some kind of like a national list or something like that. And Zoya will tell you more about that a little bit later. Public procurement. Again, as I have already said, we have a lot of changes in the sphere of public procurement, and within this section, I would like to speak about the changes to the current law of Ukraine on state procurement conduct, and I will also speak on international procurements conducted with the assistance of the specialized international organizations. And finally, I will speak on the law of Ukraine, fresh-made law of Ukraine on public procurement. Many of you may remember that in September last year, some significant changes were introduced to the law of Ukraine on state procurement conduct. As you know, the law must, or the requirements of the law must be applied if the value of the procurement subject constitutes a certain amount of money. Now, the law shall be applied if the value of the procurement subject constitutes at least 200,000 hryvnia for goods and services, and 1.5 million for works. As you can see from this slide, earlier it was 100,000 hryvnia for goods and services and 1 million for works. These value limits shall be revised on an annual basis, like every 12 months, and if necessary, the respective changes shall be introduced into the law. If any amendments are introduced to the tender documentation, this information shall be published on the respective website of the authorized agency, which is the Ministry of Economics, within 1 working day from the time when the respective decision was made. Protocol on the assessment of the tender offers or tender proposals shall be also published on the respective website after the winner is selected. There are some changes regarding the value limits for the publication of the announcement in English about the procurements. As you can see now from this slide, that if the procurement subject constitutes at least 133,000 euros for goods and services, then the announcement on the procurements shall be published in English. The law also envisages some new grounds for rejection in the public procurement for the participation in the public procurement procedures. Those new grounds are you can see those on the slide, and for the first one, for example, if there's no information in the Unified Register of Legal Entities and Individual Entrepreneurs on the ultimate beneficiary of the participant legal entity, then it shall serve as a ground for a rejection. Also, now there, under the anti-corruption legislation, I think it corresponds to the anti-corruption legislation. The participants of the public procurements in certain cases shall have an anti-corruption program or policy and an authorized person for implementation of such policy, like compliance manager. Zoya again will speak more on that within this section on the anti-corruption procedure. So I will not speak in details on this. And finally, if the information on the participant is included into the corruption register, then it also serves as a ground for rejection. Complaints to the Anti-Monopoly Committee of Ukraine for tender documentations or decisions which were made by the customer now may be submitted at any time starting from the announcement of the tender, but no later than 4 days prior to the date of the proposal's disclosure. I think this change is related to those announcements of the government authorities when they were saying that very often participants tried to block the procurements by way of submitting the respective complaints on the last day before the proposal's disclosure. So maybe they consider it as one of the ways to deal with that. Just to remind you that earlier such complaints could be submitted up to the date of the proposal's disclosure. Also, now the Anti-Monopoly Committee of Ukraine shall treat a complaint process, and provided the participant withdraws its complaint. Earlier, it was at the up to the Anti-Monopoly Committee of Ukraine. Now it's clear requirement. As you know, many proposals are often rejected due to some formal or insignificant mistakes or errors, and due to that, the respective changes were introduced into the law, and now the tender documentation shall contain a list of formal or insignificant errors which shall not be considered as a basis for rejection. For example, if the proposal is not numbered or something like that, the list of such insignificant errors shall be indicated in the documentation, tender documentation. Another interesting thing that participants now may request the committee during the proposal disclosure to demonstrate the contents of the documents with the information on the price, and see the list of the submitted documents. My only comment here would be that the legislation doesn't really explain what the word demonstrate really means. For example, if the committee demonstrates the documents at a distance, like at a distance of 5 meters, would that be considered a demonstration? My answer would be probably yes, because the law didn't really clarify that. And unfortunately, such situation may be or such gap in the legislation may be misused. Also, I would like to draw your attention to the fact that the participants now may or have a right to request uh, to request the information on the rejection reasons if their proposals were rejected. Moreover, they also may request the information on the best offer and see the comparison of the advantages, see how the best offer is better in comparison to the proposal which was rejected. Now we move to the public procurements carried out by international organizations. At the beginning of the last year, a new law was adopted which allowed the international specialized organizations to procure the necessary medicinal products and medical devices for the Ministry of Health of Ukraine. The law or such possibility is temporary, as you can see on the the final date for this is the April 1st, 2019. I believe that the government authorities think that by that time the respective concept on public procurements will be implemented, and there will be no need in involvement of international specialized organizations. At this point, there are three organizations which were selected by the Minister of Health and which have their respective contracts with the ministry. This is you can see those on the slide. And on the next slide, we try to visualize the general mechanism of such procurements. Let me comment on that. How it works. The Ministry of Health concludes a respective contract with international specialized and international specialized organizations, transfers the funds for procurement as international organizations as a rule work on a prepayment basis. The specialized organizations conduct the respective tenders and ensure that the products are supplied to the territory of Ukraine, and then on the territory of Ukraine, the respective state enterprises of the Ministry of Health deliver the products to the necessary hospitals. In order to implement this mechanism of public procurements, many bylaws were adopted, and many different changes were introduced in the respective legislation. For example, the procedure of registration for medicinal products which are procured in the course of such mechanism was simplified. The additional possibilities for prepayment were introduced. The labeling requirements were simplified, and etc. In order to ensure the import and delivery of such medicinal products and medical devices, the the resolution of the Cabinet of Ministers number 1153 was adopted. Basically, this resolution envisages the mechanism for obtaining the necessary notice from the Ministry of Health, which would confirm that the respective medicinal products and medical devices are imported and supplied in accordance with the agreements between the Minister of Health and the respective specialized organization. And this will serve as a ground for exemption from VAT. At the end of October last year, the Prime Minister ordered the Minister of Health to draft the respective resolution of the Cabinet of Ministers, which would allow to create a national agency for procurement of medicinal products. The Prime Minister emphasized that it is necessary to withdraw the Minister of Health from the public procurements, so that the ministry would focus on the reforms and its main activities. As far as we are aware, in November, the respective resolution was submitted for the consideration by the Cabinet of Ministers of Ukraine. However, there's no information on implementation of that until this moment. Law of Ukraine on public procurement, a new law which was adopted by the Parliament at the end of December and signed by the President of Ukraine only in February. This law basically introduces or establishes online or electronic procurement system, as well as electronic system of appeal. It also envisages that all information and documents will be exchanged electronically within this electronic procurement system. I would like to draw your attention to the fact that the law will be or will become effective for all participants starting from August 1st to 2016, and consequently the current law on state procurement conduct will become invalid on the same date. The law of Ukraine on public procurements envisages three procurement procedures. It's open tenders, which is a main and probably the most transparent procurement procedure. Then comparative dialogue. This procedure is used for procurement of works and services, provided some technical characteristics shall be determined first. And then negotiation procurement procedure. This is we used to call this procedure as a procedure of procurement from one participant. Basically, it didn't change. It didn't change much, and it may be used only in the specific cases provided by the law. On this slide, you can see the general procedure of open tenders, and for the time's sake, I will not comment on that. It's very it's basically very similar to the procedure which is used under the law of Ukraine on procurement, on the state procurement conduct. Complaints to the Anti-Monopoly Committee of Ukraine under the law on public procurements may be submitted again in an electronic form through a procurement electronic system, and the Anti-Monopoly Committee of Ukraine will have to consider those complaints within 15 business days and make the decision. When the decision is made during one business day, the Anti-Monopoly Committee of Ukraine shall publish the operative part of the decision in the procurement electronic system. And then within 3 days, another 3 business days, the whole decision shall be published. Competition. Again, it's as I have already said, it's a very hot topic, despite that basically no significant changes were introduced into the legislation, and it is as you know, the Anti-Monopoly Committee of Ukraine has been paying a very special attention to the pharmaceutical market, in particular to the contractual relations between manufacturer and distributor on the one hand, and manufacturer and pharmacist on the other hand. And the committee was collecting the respective information on the market. They were collecting the copies, even the copies of the contracts, and analyzed those, and trying to identify very common violations in those contracts. So on this and next slide, I will try to summarize those, and just you know, I will try quickly comment on those violations. One of those is the first one. Anti-Monopoly Committee of Ukraine determined that the contracts between manufacturer and distributor contain the requirement for the distributor to provide different reports and regular reports on the further sale of the medicinal products, like you know, the specific location or the specific purchaser, the specific region, you know, the quantity of the sold products, and even the activities of the competitors. The Anti-Monopoly Committee of Ukraine considers such reports as such which may have signs of violation of the respective legislation, and as such which may lead to the control of the market or restriction of the competition on the market. A very hot topic is discounts and bonuses. And the committee says that many contracts envisages have and the provisions which allow distributors receive different discounts and bonuses, not for some kind of achievement or extra achievement on their part, but for basically for a mere implementation of the obligations under the contract. Let me give you an example just to demonstrate what I mean. For example, the contract may contain a provision which says that the distributor shall make a prepayment, like 100 prepayment for the products, and the contract does not contain any other order of payments. Orders of payments. At the same time, the same provision may contain, and at the same time, the contract may contain a provision which says that if the distributor makes a prepayment, then in this case, the distributor is entitled to some kind of bonus or discount. So the committee says that this is just simple fulfillment of the obligations under the contract. Or another example, the contracts may contain a requirement or may contain a provision which would allow the manufacturers to instruct or recommend distributors with regard to the price for information for the products for the further sale, or they may recommend even specific legal entities, like for example, the products may be sold to the legal entities which have a certain number of pharmacies or so, or that the products may not be exported. So all of those are considered by the Anti-Monopoly Committee of Ukraine as such, which may restrict competition on the market. Or control the market, or even may lead to the unjustified increase of the prices for the products. Let's move quickly to the contracts between manufacturer and pharmacy, pharmacy change. Here the committee attracted draws attention to the specific services provided by the pharmacies. Some, they find those services very suspicious, and one of them is the maintenance of the sufficient product stock level. And here we are talking about the particular assortment of products and particular distributors, and similar service on maintenance of the sufficient remnants of particular medicinal products. In the opinion of the Anti-Monopoly Committee of Ukraine, such services, the pharmacists, of course, are interested in these contracts. But the committee says that in this case, the pharmacy may be interested in purchasing the products of the specific producer, or from the specific distributor, and thus it may lead to the restriction of the competition or control of the market. Another suspicious service is the possibility for the medical representatives to visit the trade places of pharmacy change, like in the opinion of the committee, there's nothing special about this service, and there's nothing that in this case that the pharmacy shall be paid for. And finally, the sources in the marketing contracts or the prices for the services in marketing contracts are often economically unjustified. They're too high in the opinion of the Anti-Monopoly Committee of Ukraine. So what are our recommendations in this case? Of course, we recommend to have those contracts with distributors and pharmacy chains reviewed by internal or external lawyers, and those provisions which have signs of violations shall be excluded or changed or modified. We understand that there are situations when some specific provision is very crucial for the manufacturer in this, and such, it is not obvious that this provision has signs of violation. It is ambiguous. In this case, we would recommend to use its right and address the Anti-Monopoly Committee for clarifications. All right, and I think we will move quickly. I'm sorry it took so long. We will move quickly to the anti-corruption legislation, and I will let my colleague Zoya to continue.
Good afternoon, dear friends. I need some extra time for technical peculiarities, and soon I will proceed. So good afternoon. I think we are ready to go on with the key amendments of 2015. And in particular, I want to draw attention to the main anti-corruption changes. So, as you probably know, pardon, we also have some technical problems, obstacles. Just a minute. Yeah, so again, we are ready to go on with my part of presentation within the webinar. As you probably know, on the 27th of April 2015, the new law of Ukraine on prevention of corruption has become effective. One of the peculiarities of this law is the following, that it envisaged quite many new terms, such as offense related to corruption, gift, real conflict of interest, and potential conflict of interest. In addition, considering the new anti-corruption law, we shall state that the new general limitation regarding the value of gifts that may be legally obtained by the officials of legal entities has come into force. Moreover, under the new anti-corruption law, legal entities gain new additional requirements regarding the prevention of corruption. And finally, we cannot skip the fact that the administrative liability for violation of requirements of new anti-corruption law has increased. On this slide, you see the key new terms within the anti-corruption regulations, mainly corruption offense, and the term that is well known for you, and the term that was in the previous anti-corruption law, which basically means actions that exhibit signs of corruption. And comparing with the aforementioned, the new one, offense related to corruption, does not include action that do exhibit signs of corruption. However, this offense include action that violate requirements and different restrictions of the anti-corruption law. So mainly, the legislator implemented the mechanism to bring to liability officials of legal entities if they violate the requirements of anti-corruption law, even if such violation does not contain the signs of corruption violation. The second interesting point that I want to draw your attention to is the definition of a legal benefit. In the previous anti-corruption law, the legislator identified a legal benefit by putting the closed list of advantages the promise, offering or receiving unlawfully, or which can be considered as a legal benefit. However, in the new anti-corruption law, under the new anti-corruption law, the legislator states that a legal benefit consists not only of money, property, advantages, discounts, intangibles, but of any other intangible or non-monetary benefit. The only requirement is that such advantages shall be promised, offered, given, or received unlawfully. I also want to draw your attention to the new limits of the value of gifts. Under the new anti-corruption law, the value of one-time gift constitutes one minimum salary, which, as for January 2016, equals to the sum of 1,378 Ukrainian hryvnias. And the total value of gifts received from the one source within the year constitutes now shall not exceed the sum of two subsistence minimum, which equals, as for today, almost 2,800 Ukrainian hryvnias. Another amendment that has come into force under the new anti-corruption law is new obligations put on the legal entities regarding the prevention of corruption and the obligation to elaborate and to maintain anti-corruption measures. However, it shall be emphasized that the law does not specify the procedure of such risk assessment and does not give any clues what anti-corruption measures should be implemented by the legal entities. Nevertheless, it shall be stated that the new anti-corruption law do envisage general requirements that are mandatory for all the officers and employees of legal entities. The list of such requirements you can see on this slide. I want to draw attention one more time that the obligation to perform risk assessment as well as an obligation to elaborate and implement anti-corruption measures is mandatory for all legal entities without any exceptions. One more amendment stipulated under the new adopted law of Ukraine on prevention of corruption is an obligation to elaborate and implement anti-corruption program or procedure. However, it shall be stated that this obligation, such activities are obligatory just for categories of legal entities, in particular for legal entities that plan to participate in public procurement procedure, or state or municipal entities with certain amount of employees and with certain amount of gross revenue. The exact numbers you can see on this slide. So the only thing that the legislator stated within the new anti-corruption law, just the definition of anti-corruption program. So it's a set of special rules, standards that regulate actions that need to prevent or minimize corruption risks. However, again, the new anti-corruption law does not specify the exact content of such anti-corruption program. In our professional view, it would be more than enough to demonstrate that your eagerness to comply with the new requirements, anti-corruption requirements, if you maintain for the purposes of your company due diligence review and, for instance, in case of any request from legal enforcement authorities, just provide a copy of such program. In order to control the implementation of such anti-corruption program, the previously mentioned two categories of legal entities shall appoint authorized person. The law does specify the requirements for such a person, and the list of such requirements you can see on the slide in front of you. It shall be mentioned again then that the law does not preclude any special list of subjects or any special procedure to control if such authorized person really exists. The only exception from this rule is performance or activities of legal entities that plan to participate in public procurement. What I mean is that such category of legal entities is obliged to show the evidence or to evidence the existing of anti-corruption program procedure, as well as existing of really appointed authorized person in order to participate in public procurement, and they provide a copy of the mentioned documents depending on the exact requirements of exact tender documentation. Taking all the above mentioned into account, we prepared a list of possible recommendations that will demonstrate your will to comply with the new anti-corruption legislation. For instance, in our professional view, it's a good sign to analyze the existing inner regulation relating to the prevention of corruption risks, and if necessary to modify their provisions. In addition, we kindly recommend you to elaborate some new standard provisions or instructions related to the performing of risk assessment procedure, or to the adoption of anti-corruption measures that are applicable for your company. Such standard provisions we recommend to add to the standard employment contracts, as well as supplement the existing contracts with the counterparts. Furthermore, we also recommend you to set trainings or special meetings for your employees in order to make them familiar with the new anti-corruption requirements, and so as to familiarize them with the scope of their obligations within the new anti-corruption legislation. What I mean is that according to the new anti-corruption law, all the employees of legal entities are obliged to immediately inform about any signs of corruption and any signs of conflict of interest, either real or potential. Next part of our webinar is discussion of personal data protection regulation in the pharmaceutical sphere. Although in 2015 there were no significant changes into the personal data legislation, to our mind it would be quite useful to discuss with you some shifting within the regulation of professional associations. Let me draw your attention to the peculiarities of obtaining consent of personal data subject according to the law of Ukraine on personal data protection. So if you are planning to collect, to publish, to register, to process the personal data of subject, firstly, before such actions, you need to inform such subject about your plan and to obtain his or her consent for such actions. This consent shall be mandatory of voluntary character. You can't take it by force. And of course, you need to inform the subject about his or her rights within data protection legislation, and to inform about the special purpose of such processing. I want to emphasize that you are not, or it's not obligatory to obtain the consent of this personal data subject in written form. As well, the consent may be provided in any other form, and the only one requirement for that is that such a consent shall be clearly identified within any document or by us putting a special mark in the internet system. At this point, I want to draw your attention to the new law of Ukraine on electronic commerce that has become effective within 2015. According to the scope of this newly adopted law, the electronic commerce subjects shall comply with the requirements of the law of Ukraine on personal data protection while obtaining any personal data of subjects within the electronic documents. I would like to remind you that by electronic commerce we mean relations that are carried out in distance, for instance, relation of purchasing that are carried out by the means of informational and telecommunicational systems. So, as the new adopted law on electronic commerce prescribed, the subject may provide its consent for his or her personal data processing by simply putting the mark while registering in the informational or telecommunication system of electronic commerce system. And such a consent will be full and legal. While talking about the labor relations, contract relations, marketing activities, as well as pharmacovigilance or conduct of clinical trials, the requirement of personal data protection legislation shall be taken into account. What I mean is that if a legal entity has plans to process the personal data of its employees or counterparts, the relevant provisions shall be the relevant provisions that employees or counterparts agree to the processing of their personal data shall be supplemented to your standard contracts. As well, in addition, if we are talking about the carrying out of marketing activities or clinical trials, you shall inform patients or healthcare professionals that their personal data will be processed by you, and they shall provide you a consent for such an action, in not only in written form but just in any form with clear identification of such consent. Moving further, I want to discuss with you the new obligation that were stated for the legal entities, for the pharmaceutical companies that are members of EFPIA. What I mean is that since the beginning of 2016, all the pharmaceutical companies, members of EFPIA, are obliged to document and to disclose all the information related to the transfer of values, in particular to the healthcare organization. What I mean is that all the data regarding the donations and grants provided to healthcare organizations, as well as costs related to events or costs for provision of services and consultations provided by healthcare organizations, shall be disclosed by the pharmaceutical company. Moreover, the information regarding the values transferred to healthcare professionals by the pharmaceutical company, in particular costs related to events and costs for provision of services and consultation provided by such professionals, shall be disclosed as well. The information at stake may be disclosed in two ways, either on the website of pharmaceutical company or on the website of professional organization. At this point, you shall understand that the information at stake may be disclosed on individual basis by identification of each healthcare professional that obtained the aforementioned value of particular category. And consequently, if we are talking about the disclosure of information about healthcare professional, obviously we are talking about the processing of his personal data. And at this moment, the pharmaceutical company shall ensure that it obtains the consent of the particular healthcare professional for such actions. In contrast, if the healthcare professionals just reject the idea of their data processing, all the information shall be disclosed by pharmaceutical company in general terms. For instance, the pharmaceutical company shall put the information about the general amount of healthcare professionals that obtained any values and general information about the all payments of particular category. Finally, we are moving to the prospects for regulatory changes. As you probably know, in 2015, the elaboration process of the new law of Ukraine on medicinal products has begun. Within 2015, 2 different draft laws were registered in the Parliament. In particular, on February 2015, the draft law number 2162 was registered by the Member of Parliament, Mr. Shipko, and the alternative draft law number 2162/1 was registered in the Parliament a bit later on March 2015. The author of such alternative draft law is Member of Parliament Mr. Musi. Later on, after the mutual negotiation between the 2 authors of the draft laws with the representatives of World Healthcare Organization and representatives of Ministry of Health of Ukraine, it was agreed to combine 2 draft laws and to elaborate one unified bill. As for today, the team of experts that includes inter alia associates of Legal Alliance Company has been elaborating the Unified Act and has been harmonizing the text of this combined act. It shall be emphasized that both draft laws as well as the new combined bill are based on the requirements of European directive as well as regulatory experience of European countries, members of European Union. Here, in 3 next slides, I would like to share with you the key objectives of the draft law on products that was elaborated by Legal Alliance and provision of which were also added to the combined unified recent law. For instance, our idea was to stipulate the terms re-registration of medicinal products, to stipulate simplification of entering of the medicinal products of particular categories to the market, also to amend the principles of quality control, simplify the requirements of import, as well as amend the main regulation of advertisement and information related to the medicinal products. It shall be emphasized that certain initiatives that were envisaged within the draft law on medicinal products have become already effective due to the recent amendments to the legislation that became effective in 2015. For instance, of course, we can name the termless re-registration that was discussed within the first part of this webinar by my colleague, Mr. Bonder. Another amendment that is expected in 2016 is introduction, elaboration and maintenance of national policy of medicinal products provision. What I mean is that in 2015 the representatives of World Healthcare Organization came to Ukraine and met with the representatives of Ministry of Healthcare of Ukraine, which resulted in the plan to maintain the new national drug policy. And for this particular purpose, the working group was selected, and it started the implementation of a different direction of such national policy. What is expected is the following: that in the beginning, as for beginning of July 2016, the resolution of Cabinet of Ministers of Ukraine regarding the implementation of national drug policy and the key issues of the medicinal products provision to the consumers will be adopted, and in our humble opinion, such resolution shall be deemed as the basis for the further legislative activities of the Ministry of Health of Ukraine. So the idea to adopt new national drug policy contains different directions, and the list of such directions you can see on the slide in front of you. I want to draw your attention to the fact that the expert team that includes also the lawyers of Legal Alliance Company present its view and is actively working under the improving of each direction. So as to fulfill the new national drug policy, the new national list of essential medicinal products shall be adopted as well. I want to draw your attention to the fact that since January 12th, 2016, amendments to the resolution of Cabinet of Ministers of Ukraine number 333 have become effective. What I mean is that the statement medical products were excluded from the title of the recently effective national list of essential medicinal products. As a result, it shows the real content of this legal act, due to the fact that from the outset, the national list of essential medicinal products does not contain any signs of medical products. In addition, such exclusion make real the recommendation of World Healthcare Organization that were given within the mutual meetings with respective authorities. Moreover, under the resolution of Cabinet of Ministers of Ukraine, at stake, the Ministry of Health Care of Ukraine is obliged to adopt in 1 month 3 new legal acts. You can see them on the slide in front of you. It shall be emphasized that 2 of these 3 legal acts have been already drafted and submitted for registration to the Ministry of Justice of Ukraine. And in our professional opinion, in the nearest weeks, these 2 acts shall be registered and will come into effect. So the idea of a unified national list of essential medicinal products means that all the existing lists of medicinal products that are effective, that are recently effective, will be cancelled and unified into one legal act, namely this national list. I want to draw your attention that recently 2 different national lists of medicinal products are effective, namely national list of recently amended national list of essential medicinal products that are subject for state price control, and list of medicinal products that is used for the purpose of public procurement procedure. both of these, like the principles of selection of medicinal products for this list are quite unclear, and both of this list does not satisfy the main aim of any national list of essential medicinal products. In other words, these lists do not satisfy the needs of the patients. And as you can see on this slide, we cross the obligatory assortment of medicinal products that have to be purchased by the pharmacies or pharmacy chains. My colleague, Mr. Bondar, reminded you about this recent amendment, and I want to add that this list was cancelled due to the fact that it was elaborated one time ago due to the epidemic of disease, and since then it hasn't been really reviewed, and moreover it contained some medicinal products that were also the part of other lists of medicinal products. So the idea of national list means that the recommendation of World Health Organization, namely the model list of essential medicines of World Healthcare Organization, will be included to that list. In addition, the national list will consist of two different lists. First one of the most effective, of the safest, and the mostly economically reasoned medicinal products that are used for different pathological conditions, and the second additional list for particular pathological conditions that require special medical aid. I also want to add that a national list of essential medicinal products will be elaborated using the well-known standards of such lists, for instance, the model of Scotland. And finally, I want to discuss with you the idea of the total ban of advertisement of medicinal product. Firstly, this initiative was voiced by the coalition of parties, and it was implemented to the coalition agreement between the parties in the end of 2014. And within the 2015, the idea has come again, and it was stated within the draft law of Ukraine number 3246 that was registered on October 2015. In accord with the scope of the draft law, the advertisement of all medicinal products, either OTC products or under prescription drugs for the direct consumer shall be prohibited. The only exception is advertisement within the special editions focused on the healthcare professionals, as well as sharing the advertisement information during seminars, during different round tables related to the medical issues. It shall be emphasized that the idea of total ban has been supported by the Healthcare Committee of the Parliament. However, due to our professional opinion, within the 2016, the idea of total ban will be widely discussed and severely discussed among the professionals of the pharmaceutical market, but probably luckily the chance of its being really in fact implemented to the effective legislation is not really high. So, dear friend, it is the end of our webinar, and of course we do understand that we introduced only the key amendments of the 2015, and we do understand that you may have some additional questions regarding the issues that were excluded from the scope of this webinar. As a result, we would be extremely pleased to answer all your letters and all your telephone calls regarding all the issues at stake. And the contact information, my contact information, and the contact information of my colleague, Mr. Alexander Bonder, you can see now on the slide. So thank you for your attention and have a successful day.